All right. The second case that we have that deals with these kinds of issues, again, largely for purposes of engaging some of the broader issues, not so much for the details of deed delivery, is the Rosengren case. Incidentally, the one thing that we didn't talk about, but which is vital in the Sweeney case, is that recording is not a requirement for the transfer of property. You get real benefits by recording a deed, but you can transfer property without recording a deed. You'll just have potential problems down the road. But this was a deed that was delivered, and there was intent to transfer the property, and they said that's good enough. And it really didn't matter to the court in Sweeney that there was that it wasn't recorded. It wasn't even discussed as an issue that could impede ownership. So that's something that's important. We will not talk much about, we're really not going to talk about recording. I asked you to read a couple of pages of notes on recordation system. And they're there. There's a lot more to study about recordation. It's abundantly obvious that if you transfer an interest in real property, that you should record that interest for protection against all kinds of things. Lenders should record mortgages so that if the house is sold, it will then be sold subject to their security interest. Purchasers obviously should record their deeds so that the seller doesn't pretend that they own a house and they go and sell it to somebody else. When those kinds of conflicts arise, there are various statutory schemes for who should win under certain circumstances, because often there is more than one innocent victim. Two people will have purchased the same property. Maybe one of them, there'll be some reward for actually recording. There might be some penalty for not having recorded when you could have. But nothing good is happening. I mean, you can stay there and say the person who didn't record deserves to lose to the other individual who bought. Maybe that's true, but it's really not a very happy story to have some crook that sold the property to two people, and then somebody's going to be out a lot of money and out a piece of property. That's not good under any circumstances. There's really not much controversy now about recording, and nobody would buy a piece of property and not record it under ordinary commercial circumstances. So the kinds of situations which you really have to watch out for are when members of a family give things to each other for their birthdays, where they're just kind of doing it privately because they sort of have history of independence and this sort of thing. And you'll still see some of that elsewhere in the country, but not much. And you're certainly not going to see it very much around a commercial center like New York. It's not really much of an issue. Yeah.
Aren't like real estate taxes based on the recorded owner of the property? So if somebody would do a deed and not record it, how would the city ever tax the right person?
Well, that's right. I mean, if you sold the property and you keep on, and nobody said that you don't own it anymore, obviously you're not. Well, in family situations, it might just happen casually like that. Oh, look, we keep getting these bills. Don't worry, Dad, I own the property now. But other than that, that's what I was saying. It's not typically something that's a serious problem right now. It's a serious problem with respect to failure to record earlier. It happens out on Long Island a fair amount with some of the older estates where they've been broken up potentially without recording, and sometimes there are peculiar easements or sometimes even adverse possession claims. But I don't want to make light of it, but there is a mature system of recording of property all around the United States, and it works fairly well, and the consequences of not doing it vary from place to place. And you saw the race notice kinds of statutes that are mentioned in the book. There are plenty of cases in which it does happen occasionally still. So there are cases that occur that show how these things apply as a mechanical matter. I just didn't put it in the syllabus because we can't do everything. And as you can see, we're not moving with lightning speed here through the course. Although after tonight, we'll have read a couple of hundred pages already. But may not feel it, but it kind of sneaks up on us, so we're moving at the pace that the course is designed to move at. But we're not going to be talking much more about that. Well, let's get to Rosengrant. Again, I think I'll start by talking about the facts. Harold and Mildred Rosengrant, this is a case from Oklahoma in 1981. Harold and Mildred Rosengrant want to give their farm to Jay upon their death. Jay is their favorite nephew. Maybe some of you are favorite nieces or nephews of somebody. It's nice. So they go to the bank and they deliver the deed to make it legal. Then Jay says, okay, here's the deed, I'll give it to you for safekeeping. Because now a deed from the Rosengrants to their nephew Jay, but they really don't want it to be valid until after their death, so they have the banker holding the deed. And the banker puts in an envelope that says J.W. Rosengrant or Harold H. Rosengrant. That's what the envelope says. Then, 2 years later, Harold and Mildred consult an attorney to see if they did this right, and the attorney says there really shouldn't be any problem. Uh-oh. They lose. How come they lost? It's terrible. You have some very nice people. They're trying to give their farm to their nephew without causing a big stir over it with the rest of the family. They want to make a gesture. Yes?
It was testamentary ritual. Because it didn't go into effect until they died, and he did an extra possession of it. They basically holding it in a bank, which was acting as an agent for the couple, not for their nephew. And the fact that he handed it to him, but then put it right back into his own bank's vault, not to be given out to him until after they died. Because essentially,
Well, what right did the Rosengrants, Rosencrantz is a character from Hamlet. what right did the Rosengrants maintain or retain that the court was very concerned about? Yes?
Revocability. When he put or Harold on the envelope and gave it to his own agent, it meant that he could always snag it back if he wanted to.
They said, gee, you can always go back to the bank and say, you know, remember when I gave that deed to my nephew and it said, well, you know, that until we die, yeah, well, we had a falling out with Jay. Do you know that Jay forgot my wife's birthday 2 years in a row? He always would come. He came for dinner all the time and he helped out. Once we transferred that deed, he figured that he got what he wanted and we stopped seeing him. And in fact, you know, they slipped out. The other nieces and nephews heard about it, and they didn't think this was a good idea either. And they were kind enough to tell us about what a terrible person Jay is. So we decided to get rid of this deed, and we did. Now, if they could have done that, and it's really questionable as to whether they could have, but I guess they could have. Then they're saying, well, you didn't really give it to, that you didn't give it to them, to the banker on the condition that Jay's going to get it exactly upon the death of the second of them to die, and therefore it wasn't a valid transfer. It looks an awful lot like it looks like the Rosengrants did almost exactly what the Sweeney court said you had to do. The Sweeney court said, well, you can't just give it to somebody conditionally. That counts as giving it to them as if there were no conditions. But you could give it to an escrow agent, making it clear what the conditions are for you to pass it on for the escrow agent to pass it on to somebody else. And then you can make some kind of conditional transfer like that. So they came awfully close. Again, here's what they wanted to do. It's not illegal to do something like that. What could they have done? And it wasn't a will, you're absolutely right. The courts are not too wild about people coming up with schemes to avoid writing a will. I guess they didn't want to put in their will that they're leaving the most valuable possession to Jay, because it might offend other relatives. and they wanted to have a ceremony while they were alive, giving the property to Jay right then to take effect as of their death. It's the same way that Mr. Gruen, the architect, wanted his son to have that painting. The gift wouldn't take effect until after his death, but it's nice for his son's 21st birthday to give him a painting right then, instead of saying, well, it'll look like I've never been nice to you until I'm dead. It's kind of nice to be able to do things like that. These people just seem like ordinary people trying to accomplish something. Yes?
You can set up a local trust, make it
Yes. How would that have worked?
they were served as trustees, I believe, and they would have received a life estate, and then the nephew got a remainder.
Yes, so what they would have done is they could have formed a trust. We've talked about trusts a few times in class, and I just want you to get accustomed to the concept of trusts as something that will help increase flexibility with respect to the disposition of property. So one thing that they could have done is gone to a lawyer. That's already something that people are not always too thrilled about doing until after it's too late and everybody's fighting with one another. And they could have said, what we'd like to make sure that our nephew Jay gets this property, and but we want, who knows what's going to happen. You know, we're doing okay now, but just in case something happens, can we still change our mind, but take care of the situation right now? And the lawyer could say, yes, why don't you transfer your house, which is now owned jointly by you, to a trust, and we'll call it the Rosengrant Trust. And you'll have to put something in the trust, otherwise that doesn't make much sense. And what you should put in the trust is, of course, the house. So the house, you're going to write a deed from from H&M Rosengrant to the Rosengrant Trust. Now, you'll record that deed. Now, the Rosengrant Trust owns that house. And the terms of the trust are as follows. The only purpose of the trust is to own the house. And the trustees shall be, and it might be their banker friend, you can just appoint him as trustee, there's hardly any work to do. And the terms shall be as follows. While H or M is still alive, they'll continue living there, they'll continue paying the taxes, and they will maintain a life estate, a joint life estate that will only end when the second of them passes away. And at that point, the trustee shall write a deed from the trust to our nephew Jay. So now the trust will no longer own it, Jay will own it, and the trust shall at that point terminate. And that's what will happen. So you'll have first a transfer from the Rosengrants to the trust, followed upon the death of the second of them, a transfer from the trust to Jay. And in that trust document, it'll say that not only will it say that the bank is appointed, or the banker or some particular individual is appointed as the trustee. Again, there's hardly anything you have to do, but it will also say that the trust can be revoked by either Rosengrant simply by doing whatever you have to do, just sending a notification to the trustee that the trust is going to be revoked. In the event that this letter comes, that the trustee immediately shall effect a deed transferring it from the trust back to them as joint tenants, and they'll own again. That's perfectly legal. There's no will. There's a recording only of the ownership of the trust. There's not much more notice than there is here. There's more formality with a trust, but not an enormous amount of extra formality. And going to the bank with an envelope is not wildly different from having this big document that doesn't say any more than I've just told you. So, what are the concerns? I mean, it's relevant. What do you accomplish by allowing a revocable trust, but not allowing what the Rosengrants actually did? The Rosengrants lost, but they would have won if they had just made a revocable trust. But they lost because the arrangement they made was revocable. So it can't be that the law doesn't allow one to decide to give property to one's nephew upon one's death, and then, it disallows that kind of gift as long as it's revocable, because they put it in a trust. If they die, the fact that the trust was revocable won't make it invalid with respect to Jay getting the property. Yes?
Well, if they didn't have a will, and they died intestate, and all they were survived by were those 6 nieces and nephews, then most probably their assets would have been sold and distributed to all 6, not just to the sole one.
For certain.
Which is what they wanted.
Exactly. But why should they have been allowed to accomplish what they wanted to accomplish through a revocable trust, but not accomplish it through the procedure that they engaged in? It would seem perfectly above board. It wasn't like the Sweeney brothers sneaking around to try to avoid a statute. I mean, if they go to a bank, it all seemed perfectly dignified. It seemed like a nice thing that 2 older people are doing for their nephew. It didn't seem like there was anything wrong. In the Sweeney case, we sort of explained, at least in part, from a legal realism perspective, well, if they're really complaining about the formality, the court's complaining about the formality, the truth is they're trying to protect spouses, and even if this wasn't the best marriage in the world, what kind of a state highest court would want to have decisions that seem to be insufficiently respectful of marriage? But you don't have anything like that here. What's the difference? Yes?
With a trust, they have to revoke this joint tenants. We have a power to effectively revoke just like own. Because of what it says on the...
Yeah, that's probably true. That might be one difference. And there's another difference. Let's say that there's some kind of a... That's right. And let's say there's some kind of a fight. In fact, there was a fight here. What was the evidence in this fight? Yes? The envelope and testimony about people remembering things that happened. What if people don't remember it? Or what if people lie? Or what if people remember it differently? If you have a trust, it might be revocable. And no doubt that there are disputes over the terms of trusts and whether people have abided by their conditions and so on. But if you have a trust and the property's been officially transferred to the trust, and all the Rosengrants have to do is write a letter to the banker if they want to revoke the trust, either they've done it or they haven't done it. And while one can have rather difficult situations as to whether it's something that more or less complies with the terms of the trust, substantial compliance doesn't, and so on, you're more likely not to have a great deal of dispute about what the facts are, but at least you go through that much formality. In neither case do you have to make a will, incidentally. And incidentally, wills are revocable until death. So if the 2 spouses had wills that said, to my beloved spouse, but if I survive, to my beloved spouse, or if it's jointly held, you don't even have to do that. If the property was jointly held, the surviving spouse gets the property, and then you'd say, well, if I survive my spouse, I hereby leave this property to my nephew Jay. But you could revoke that while you're alive. There's no reason why you can't. So wills are revocable up until death. This arrangement was revocable. So were trusts. This arrangement was too informal for the law, though. Yes?
If someone does both, let's assume they prepare a will, leaving the property to one nephew, and then do a deed to another nephew, which doesn't get recorded. Which supersedes, the will or the deed?
So say it again.
If someone leaves one piece of property to one nephew by his will, and then he deeds the same property by a deed to another nephew.
The will doesn't really count until that person dies. So if he's already deeded it to the second nephew before he dies, in all likelihood it's not part of his estate at the time he dies. Typically that will be the answer. Obviously there are circumstances that would make it so it's not the answer, but typically that's what the answer is. So you don't have heirs until you've died. You have potential heirs. And that, all wills are revocable until that.
And if it would have been the same way he did it here, with giving it to an escrow agent and just putting a name on the envelope, then you would have had a problem, wouldn't you?
Yes. You know, they have there's a rule against revocable escrows here, and it seems a little bit at odds with the other case. But they're trying to, these rules obviously are to avert fraud and to reduce the legal system's burden of having to deal with conflicts of proof when it's not at all clear about what happened years ago. You're dealing with people, you know, who are obviously not in great shape. That is, if, let's say that this happened a long time ago and one person's now died, the other person's old and infirm, some of the witnesses are dead, some of the witnesses have moved away. You can avoid a lot of that by setting up procedures in which that's not the core of how the property system works. But I'll tell you right now, the people who are out are the people who just don't want to hire lawyers. Now, right now, we live in a legalistic enough society that you can say, well, I guess you'd better hire a lawyer to do one of these trusts. It's not terribly expensive to have something like that done. It's not really that big a deal. But it's expensive enough that if you don't like dealing with lawyers, you don't want to pay for it, you think you should be able to go down to the bank and handle it as decent people who don't mean anybody any harm. The answer is, well, you can't. Society doesn't let you do that, so there are limitations on freedom for the sake of the formality of the property system in these situations. But it's not absolute. None of this is subject to the statute of wills unless you convey the property in a will. So, I guess if you want to have a hierarchy, there's less likely to be fraud if an escrow agent has to testify, which would justify the Sweeney priority. And there's less chance of fraud even still if you're not going to really require the testimony of the escrow agent. And because you've done it all through more formal methods of property conveyance. Any questions? Yes. Well, that's a good reason to have a question.
In both cases, if there were no conditions, then to whom the property was deeded, they would have won.
But you see, you're right, but it wouldn't have happened that way mechanically either. I mean, if John really just wanted to give the property to Maurice and gave it to Maurice, then it's Maurice's property. But of course, then it was the condition that was supposed to serve the purpose of keeping that property away from Maurice's wife. So yes, if you deed it without condition, you don't have any of these problems. But the question is, what happens if you really want the condition? That's really what they're trying to accomplish with all of this. And some of the conditions may not be entirely legitimate societally. Disinheritance of a spouse is one of them. You're going to see how hard it is when we get to this in 4 weeks or so. But but disinheriting one set of nieces and nephews in favor of another who's been, loved more, there's nothing wrong with that. So, but you're right. If there hadn't been any kind of conditions, they just would have given it to Jay. Jay could have just kept the property, or they could have maintained life estates, either through a trust or otherwise, and deeded it that way. Then, of course, Jay's ownership would be public immediately. Doing it through a trust, it wouldn't be public immediately.
Or should I say, if there was no evidence of the property being, the property being revoked?
Then that's right. If they had said this is irrevocable, then the court would have said, well, now there can't be any controversy. It's just a matter of, there is an escrow agent, but it's really just a matter of mechanical situation. Somebody took a deed, placed it in escrow with an escrow agent who could, the escrow agent himself had died, but the terms of the escrow were clear enough that that we're willing to take our chances. Could there be fraud? Yes, but less likely to be fraud in a situation like that. The message, of course, is to get a lawyer who will do this either through specific transactions of life estates or transfer to a trust, right, in terms of the revocable trust. In this case, that would be the preferred way of going about it. Oh, not only get a lawyer, you're the lawyer. I mean, tell potential clients who are relaxed about these kinds of things, as you began the class saying, that it's maybe not something you should be quite as relaxed about as you are. Anything else? Yes?
So is a revocable deed generally invalid?
It's really, they don't really talk about revocable deeds. This was it was a transfer of a deed into escrow, where they're saying that it was, well, I guess did they call it a revocable deed?
Well, in notes, on page 643, like the third paragraph, or
Right.
says why is a revocable trust valid, whereas in some jurisdictions a revocable deed is not.
Well, that's I guess in essence, this really is a revocable deed, is what the court is saying. It's saying that you gave him a deed, you delivered it, but you retained the right to revoke your transfer of this by taking the deed and tearing it up. And that's really the question we've been addressing, why you can't do that, but you could have transferred it to a trust, made the trust revocable so you can get the house back the same way, and you would have had to pay a lawyer. Whereas here, you could just go to the bank and have people whom you trust take care of it, and the court didn't accept it. So that's really, yeah, I mean, that's the editor's way of addressing the question that we've been addressing.
Right, I'm just not clear as to, because it says in some jurisdictions, which sort of implies that in some jurisdictions a revocable deed could be valid.
Well, as you can see, I mean, if you compare Sweeney and Rosencrantz, the courts seem to have different standards as where they draw the line with respect to formalities. In Sweeney, you had a deed that, in essence, was supposed to be revocable in the sense that I'm giving it to, John's giving it to Maurice in the event of one dying before the other, otherwise it'd just be thrown away. And if you throw it away, it means it was sort of a revocable delivery. It was delivered on condition of something, but otherwise we'll try to revoke it. The question isn't whether you can revoke, jurisdictions will differ with respect to how you can accomplish these kinds of things. But there are no jurisdictions that say you can't ultimately accomplish this purpose. So now you have three ways of doing it. One of them is the way we saw in the Sweeney case, where people are just doing it between them. Well, that's pretty much out. Another one is this Rosencrantz case, which will vary from jurisdiction to jurisdiction about whether an escrow agent can hold a deed and then it'll be valid if the transfer could have been revoked before the conditions met. This court said it's not valid. The editors suggest that there might have come out in other jurisdictions. Revocable trust will be valid everywhere. So the real question we want to ask is why that hierarchy and what advice one should give one's clients in any event. And the advice clearly is to abide by whatever formalities are required. The whole business here is concerns about such things as fraud and the statutes of wills. Courts, as we saw earlier, get a little nervous when people try to do things in a way that will evade the formalities required for transfer of property upon death. We saw it in Gruen, although it worked. We saw it in White versus Brown, and now we're seeing it here in these cases. Yes?
I have another question, because I somehow recall hearing or remembering that if a deed is not recorded during the lifetime of the grantor, there can be a problem with that deed. So these deeds that were done, that were quote-unquote these revocable deeds, that's really what these deeds were. Weren't they going to be held and only in the so I don't know if there's an answer to my question, but I'm pretty sure that today there's a problem if the deed does not get recorded during the lifetime of the grantor.
I honestly can't speak to that. Anything else? Yes?
Just a very small question. The only thing that points to the irrevocability of the deed in Rosengrant is the envelope, which the banker wrote. So why is there never a question as to whether the banker actually accurately reflected the intent of the will?
Because the banker's not there. Banker died. So you can see this case, this is not a case that really has to come out this way. And it reflects an uneasiness that courts have with people making private, informal arrangements with respect to the transfer of property upon death. Ordinarily, that whole group of nieces and nephews would get that property. And there was some kind of a private transaction that occurred among a small group of people without following the kinds of formalities that the courts usually like to see. The question is, how much our society will let people conduct their business that way? These people certainly weren't doing anything dishonorable. And the answer is, they draw the line in a place where perhaps you wouldn't draw it. There wasn't any fraud going on here that anybody's even accusing him. But you certainly had a lot of very unhappy relatives coming in saying, what's going on here? Well, they gave it to me, it's in this envelope. You see some envelope with some initials on it, you don't even know what it is, and the person who received it is not alive. And it's not at all clear that this was really, their lawyer, I'm sure the lawyer for the nieces and nephews are the ones who raised the question. Well, who knows that this was really a gift, or they just decided to put it in escrow on the condition that if they wanted this to be recorded and to actually be a gift, it was there already in case they became too infirm to do it themselves. And they could have changed their minds. And there wasn't anything there that said they couldn't change their minds. And the one way of making sure you don't change your mind is to give it to the people. But it certainly seems to be thwarting the intent of the grantors in this case for the sake of abiding by formalities. The people you don't see in this story are the nieces and nephews and their lawyer. It is conceivable that there was a moderately sympathetic story that they were telling that influenced the court at the margins here, but I don't really know that. It's just possible. Anything else? Maybe from this side of the room? Okay. I'll see you in 15 minutes.